Welcome to the deep dive. Today, we're digging into something fascinating. Contracts gone wrong because of a shared mistake. Think high stakes, like buying a vintage violin for thousands, only to find out it's not what you thought. When does a mutual misunderstanding let someone back out of a deal? We're going to dissect the case, Bentley v. Slavik. It involved exactly that, a pricey violin sale. And we'll look at two ways the buyer tried to get relief. One is breach of warranty, kind of a broken promise. The other, trickier one is mutual mistake and this idea of assuming the risk.
Right, and that second path, mutual mistake, really hinges on a subtle legal idea. It's about whether you were just mistaken, or if you were, let's say, consciously ignorant. Basically, did you know you didn't know the full truth, but went ahead anyway? That's the key.
Okay, let's tackle the simpler argument first, the commercial law one. What's the rule about when a seller's description becomes, an actual guarantee?
That's covered by the Uniform Commercial Code, the UCC. The general rule, UCC Section 2313, says an express warranty is created if a seller's description of the goods becomes a part of the basis of the bargain.
Basis of the bargain, meaning?
Meaning is part of the reason you decided to buy it. If you're relying on that description, the seller's basically promising the item matches it. And this isn't a new idea. You might remember the old Smith v. Dimbalist case, the violin case.
Oh, the Stradivarius one. Yeah.
Exactly. The seller just wrote Stradivarius and Guarnerius on the bill of sale. The court said, yep, that description alone was an express warranty. Simple as that.
Okay, makes sense. So let's apply that to Bentley v. Slavik. The facts were, seller Charles Slavik advertised an Auguste Sebastian Philippe Bernardo violin made in 1835. Said it was worth $15,000, $20,000. He even gave the buyer, Karen Bentley, a certificate of estimation from someone named Tipple. The bill of sale said one Bernardo ASP violin. Bentley paid $17,500. But later, experts checked it out. Actual value, maybe $2,000? So what did the court say about the warranty claim?
Well, the court found pretty clearly that an express warranty was created. They looked at the advertisement, that certificate, and crucially, the specific description on the bill of sale. Taken together, it was obvious the identity of the violin being a Bernardo was fundamental to the deal. It was absolutely part of the basis of the bargain.
So since it wasn't a Bernardo...
Slavik breached the express warranty, plain and simple.
Okay, breach established. So what were the damages? How much money did Bentley get back based on that?
The UCC, Section 2714, subsection 2, spells this out. The damages are the difference between the value the goods would have had if they were as warranted.
Which is the $17,500 she paid.
Right. The court used the purchase price as the warranted value, and you subtract the value of the goods she actually got.
The $2,000 value.
Exactly. So $17,500 minus $2,000. The damages came out to $15,500. It's meant to give the buyer the benefit of the bargain they thought they were making.
$15,500. Okay, so a clear win on the warranty claim. But the court didn't stop there, right? They also looked at this other argument, mutual mistake. What if, say, the paperwork hadn't been so clear? Could she still have gotten out of the deal based on just the shared mistake?
Yes, and that's where we shift from the UCC to common law contract defenses. The rule for mutual mistake comes from the Restatement, Second of Contracts, Section 152. Basically says a contract can be voided by the party who's harmed by the mistake, IF. If both parties made a mistake about a basic assumption, it has a material effect on the deal, A&D. This is the big one. The harmed party didn't bear the risk of that mistake.
Didn't bear the risk. Okay, that sounds critical. Let's walk through Bentley v. Slavik using that rule element by element. First, what are the key facts the court focused on regarding the mistake itself?
Okay, the essential facts for the mistake claim were both Slavik, the seller, and Bentley, the buyer, genuinely believed the violin was an 1835 Bernardo worth around $17,500. They both relied, at least partly, on that Tipple certificate. Then it was definitively proven by other experts that it wasn't a Bernardo and its real value was only $2,000. And importantly, the court found Slavik wasn't committing fraud. He was mistaken too, a shared error.
Got it. So, based on those facts, what was the core legal issue the court had to decide for the mutual mistake claim?
The issue was really two parts. First, was there actually a mutual mistake about a basic assumption here, the violin's authenticity? And second, if yes, did Bentley, the buyer, assume the risk that the belief might be wrong? Because if she did, she couldn't use the mistake defense.
Okay, and what rule did the court apply to answer that? You mentioned Restatement 152. Can you break down its elements for us?
Sure. So, Restatement Section 152 requires the party trying to void the contract here, Bentley, to prove four things. One, there was a mistake by both parties when the contract was made. 2, that mistake concerned a basic assumption underlying the contract. 3, the mistake had a material effect on the agreed exchange of performances. And 4, the party seeking relief again, Bentley did not bear the risk of the mistake, according to the rules in another section, Section 154. All 4 have to be met.
Thank you. That's clear. Now for the court's elemental analysis. Let's go step by step. How did the court handle those first 3 elements? Mistake by both, basic assumption, material effect.
Those were relatively straightforward for the court. Element 1, mistake by both parties. Yes, check. Both thought it was a Bernardo. Element 2, basic assumption. Yes, check. The maker of a vintage violin is fundamental, not just a minor quality detail. Element 3, material effect. Absolutely check. The difference between a $17,500 violin and a $2,000 violin is obviously material to the price paid. So the first 3 elements were satisfied.
Understood. Okay, now the crucial one. Element 4, assumption of risk. This gets to that idea of conscious ignorance under Section 154. How did the court analyze whether Bentley bore the risk? What's the sub-rule there?
Right, this is the key differentiator. The sub-rule, drawing from Section 154 in cases like Harley v. Magnolia Petroleum, is that a party bears the risk of a mistake if they are aware, when making the contract, that they only have limited knowledge about a crucial fact, but they treat that limited knowledge as sufficient. It's sometimes called conscious ignorance, or having an attitude of indifference to the truth. You basically know you might be wrong, but you proceed anyway. You're taking a gamble.
Okay, so did the court find Bentley was gambling? How did they apply that test to her actions?
They found she wasn't gambling. The evidence showed Bentley relied heavily on Slavik's specific representations, the ad, the description, the certificate. She seemed convinced it was a Bernardo. The court reasoned she wouldn't have paid that high price if she thought there was a real risk it was a fake. Her belief was based on the information provided by the seller. She wasn't acting with conscious ignorance.
So it's about her state of mind. Because she relied on the seller's certainty, she wasn't consciously aware of or indifferent to the possibility of error. She thought the fact was known.
Precisely. She was mistaken, yes. Ignorant of the true facts. But not consciously ignorant in the legal sense required to make her assume the risk. She relied on what she was told. Therefore, the court concluded that the 4th element was also met. Bentley did not assume the risk of the mistake.
Okay. And after analyzing all 4 elements, finding they were all met, what was the court's final conclusion on the mutual mistake claim?
The ultimate holding was that because all elements of Section 152 were satisfied, a mutual mistake of fact existed that allowed Bentley to void the contract. The remedy granted was essentially the return of the excess purchase price, that $15,500 again. So, interestingly, she won under both theories, warranty and mistake, and the financial result was the same. But the legal journey to get there was quite different.
That difference between just being wrong and knowing you might be wrong seems subtle but huge. Let's try a hypothetical to make it stick. Okay, imagine you go to a storage unit auction. You see a filthy sealed box. The auctioneer says nothing about its contents. You bid $1,000 for it thinking, hey, maybe it's full of jewelry, maybe it's full of junk. You win, pay the $1,000. You open it, and it's just old newspapers, worthless. Could you use mutual mistake to get your $1,000 back?
No, absolutely not. That's a classic case of conscious ignorance. You didn't know what was in the box. The very nature of the transaction was a gamble on unknown contents. You explicitly assumed the risk that it might be worthless garbage when you placed your bid. Your limited knowledge was treated as sufficient.
Right, because the uncertainty was baked into the deal itself. But what if? What if the auctioneer had held up the box and said, this sealed box contains a certified, signed first edition Hemingway novel? And then you paid $1,000 based on that statement, opened it, and found only newspapers.
Now that changes everything. Now it's much closer to Bentley. You relied on a specific factual representation from the seller about the contents. You weren't consciously ignorant about the nature of the item. You were mistaken because the seller's statement was false. In that case, you'd have a strong argument for relief, either under warranty based on the description or under mutual mistake because you didn't assume the risk of the seller's statement being wrong.
Got it. That really clarifies the conscious ignorance part. Okay, so wrapping this all up, can you synthesize these 2 paths, warranty and mistake, into a kind of diagnostic checklist for analyzing these situations, like for someone facing a similar problem?
Definitely. Think of it as a 2-step issue spotting framework. Step 1, check for commercial warranty, ECP. First, always look for an express warranty. Did the seller make a specific promise or description about the goods? Words, ads, certificates, samples, anything. Was that description part of the basis of the bargain? Meaning, did the buyer likely rely on it? If yes to both, you likely have an express warranty. If the goods don't match, it's a breach. The usual remedy, difference in value. Step 2. If no clear warranty, check for mutual mistake, common law path. If a warranty claim seems weak or maybe doesn't fully cover the issue, then pivot to mutual mistake. Mistake element check. Ask, were both parties wrong about something fundamental? A basic assumption. Did that mistake have a material impact on the value or the deal? The decisive element, risk. Then, the crucial question. Did the party trying to get out of the deal assume the risk of that mistake? Were they consciously ignorant? Did they know they had limited info but went ahead anyway? Or did they reasonably believe the facts were certain, perhaps relying on the other party? If they didn't assume the risk, like Bentley, and the other mistake elements are met, the contract is likely voidable. If they did assume the risk, like the storage box buyer, the mistake defense fails.
That's a really useful framework. Warranty first, then mistake, with the assumption of risk as the critical hurdle for mistake claims. The court in Bentley made an interesting point. It said the law can't really fix the hurt feelings, the seller's pride, the buyer feeling ripped off, but the law can be consistent. And here, whether through warranty or mistake, the consistent result was, if the thing you bought isn't fundamentally what everyone thought it was, the law usually provides a way to fix the financial unfairness.
That's right. And that consistency raises a modern question, doesn't it? Think about today. With incredible technology for authenticating things, high-res imaging, chemical analysis, AI, if Bentley were buying that violin today, with easy access to sophisticated testing, would a court still say she didn't assume any risk by relying solely on the seller's old certificate? Does the buyer's duty to investigate increase with technology? Could failing to use available tools make a buyer seem more, consciously ignorant today than maybe 50 years ago? It makes you wonder how these fundamental rules adapt. What stands out to you about that?
That's a really provocative thought. Does modern tech shift the burden of who bears the risk of uncertainty? Something definitely worth pondering. Use this framework we've discussed today, warranty, mistake, and that crucial assumption of risk analysis next time you encounter a deal gone wrong. Keep digging deeper.